Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We would talk today about an unusual and might say highly unexpected target of economic sanctions imposed by a major power, the International Criminal Court. And the purpose why I thought it's useful to discuss the sanctions against the International Criminal Court is to illustrate the proposition that the conventional wisdom that sanctions is something which affects terrorists, people responsible for war crimes, genocide, is not correct any longer. Sanctions is becoming more and more a tool of politics rather than law. And the example which we will discuss today demonstrates this point when the institution which sole purpose is in effect to prosecute those responsible for most heinous crimes ever committed, war crimes, genocide, crimes against humanity, are subject to the sanctions themselves. And more specifically, we would discuss today several points. I would first talk about the ICC. We would discuss this institution in general terms. We would then briefly set this into the perspective of the US-ICC relationship, and we would describe how difficult and how uncertain this relationship has been. Then we will touch upon the executive order, which actually introduced the sanctions against various ICC judges and members of the prosecution office, and we will conclude by some takeaways of what one can draw from this example as to the overall development of the international economic sanctions today. So the International Criminal Court was established in 1998 in Rome when the statute was signed, establishing the permanent court, and that followed up on the previous work of the United Nations by establishing ad hoc criminal tribunals for Yugoslavia, Rwanda, which in their turn followed on the post-World War II tribunals of Nuremberg and Tokyo. The idea was to create a permanent international court which would be authorized to deal with the most atrocious crimes. The statute ultimately, and the court itself, proved to be a success. 125 countries are parties to the ICC today, which is the majority of countries in the world, which proves that its objectives are generally appreciated by the international community. The ICC has limited jurisdiction, so it's not open to ICC to adjudicate on all sorts of crimes. Its jurisdiction is strictly limited to considering the crime of genocide, crime against humanity, war crimes, and crimes of aggression. It's important to note that the ICC is not replacing the national courts in terms of investigating even these crimes. The ICC has complementary jurisdiction to the national courts, meaning that to the extent the relevant crimes are investigated at the national level, the ICC does not step in, and it's only in the circumstances when the local law enforcement and judiciary is not taking steps to prosecute the perpetrators of the relevant crimes, or in the circumstances when the relevant state where those crimes were perpetrated believes that the matter should be better handled by an international court, that the ICC steps in. The principle of complementarity is not just a matter of a principle, how the ICC operates. There are also various procedural provisions whereby the principle can be observed. So, for example, national member states parties to the ICC can request an ICC to defer the investigations pending the relevant investigations at the national level. At the general point, the investigation may be started upon referral of a state party to the ICC or the UN Security Council, in which case the prosecutor is obliged to start the investigation. And to the extent he or she refuses, then this refusal may be revised by the pretrial chamber. The prosecutor can also start the investigation of his own initiative, in which case to proceed to the formal steps, like the issue of warrants, for example, the prosecutor needs to get the approval of the pretrial chamber to proceed with the matter. The process would be largely similar to the criminal investigation process in local courts, whereby a preliminary investigation stage is started by prosecutor liaising with various victims or NGOs or civil society members or human rights advocates, which bring to the attention of the prosecutor various situations which can result in the formal investigations. This is an important stage because certainly ICC has no investigative capacity which would permit it to investigate on its own initiative various situations where war crimes or crimes against humanity occur, and it's very much reliant on proactive operation of the NGOs and local communities of bringing those situations for the purpose of its initial assessment. Once that initial assessment is complete, which refers to both the material element of the matter, that the crimes have, that there is real evidence that the crimes could have occurred, and the ICC has jurisdiction over the matter, at least prima facie, both in terms of its complementarity, in terms of timing when the crimes allegedly occurred, territory or the persons who perpetrated the crimes. Then the formal investigation starts, which, to the extent initiated by the prosecutor, would require the pretrial chamber approval. The formal stage of the investigation, the formal suspects will be identified, warrants will be issued. Following that investigation, the approval will be sought to the extent the matter shall proceed to trial, and this is followed by trial itself, appeals, and enforcement. By looking at the relationship between the United States and the ICC, the overall conclusion is that this relationship is far from being black or white. Whilst the United States have historically been suspicious of the ICC, having its reservations with respect to the potential risks which this court may create for the US military operations outside of the US, nevertheless, the US signed the ICC statute, although later withdrew its signature, and over a time supported more than refused to cooperate with the ICC as a non-party. For example, with respect to the situation in the Democratic Republic of the Congo, the United States actively participated in providing data and arrest of some of the persons accused of crimes committed in this country. Same occurred with Uganda. United States supported the ICC investigations of the situation in Venezuela, Central African Republic, and other countries. More importantly, the US, as a permanent member of the UN Security Council, either tacitly, by abstaining from vote or voting in favor, authorized the referrals to the ICC of the situations in Darfur and Libya. Having said this, on the other side, the United States certainly withdrew from the ICC statute, has never ratified the statute itself. And in fairness, in 2002, Congress interfered by passing American Servicemen Protection Act, also colloquially known as Invading the Hague Act, which in essence prohibited for the US authorities to cooperate with the ICC on various matters, and even authorized the US president to do whatever is necessary to protect the US military personnel to the extent any of them is detained or arrested by the ICC, which was the reason for the rightful name of this act. But again, even this part of history was not as simple as one might think. For example, in 2022, Congress amended this prohibition to cooperate with the ICC with respect to the situation in Ukraine when the relevant prohibitions were lifted. So despite this mixed history, when President Trump came into the office late 2024, almost immediately at the beginning of 2025, he passed an executive order imposing blocking sanctions on certain persons related to the ICC, being the judges or the members of the Office of the Prosecutor. This was not the first attempt to impose this type of sanctions against the ICC. The previous one was done during the first term of President Trump. At the relevant time, it was challenged and declared invalid by the relevant courts. And this is the second attempt along the same lines. Important to note is that the executive order imposes blocking sanctions against the relevant persons, and these would be identical to the same type of blocking sanctions which are imposed by the US against the likes of Taliban, Al-Qaeda, North Korea, or Iran. So these are the harshest and most restrictive type of measures which can be imposed by the US. And in essence, they boil down to three main points. The first point is that all property of the relevant designated persons within the United States or somehow controlled by the US persons outside of the United States is blocked. No goods, services, or funds can be provided to such persons or received from them. Specifically, the reference to services is a reference to a very broad term. Any type of assistance can be classified and is classified by OFAC as services. And given that the prosecutor of the ICC, Mr. Han, was the first person to be designated pursuant to this order, and given that the provision of services is classified by OFAC as covering both direct and indirect provision of services, arguably any type of benefits whatsoever provided by the US persons to the ICC would in one way or another indirectly be for the benefit of its prosecution office, which is the integral part of the ICC, and for that reason be prohibited. And then the third element of the blocking sanction statute is the travel ban prohibition for the designated persons and their close family members. Important though, and as is typical with the US blocking sanctions program, the order does not refer just to the prohibitions which are relevant for the US persons. Again, it uses its standard language, and accordingly, the relevant prohibitions apply to the US persons in the way which we've just described, but also the order mentions that the foreign persons, meaning non-US persons, are subject to the risk of the potential designation to the extent they are engaged in any investigations with respect to the US military personnel or the military personnel of the US allies who have not consented to the jurisdiction of the ICC by signing its statute, which would be consistent with the overall purpose of the order, but it goes further and it says that also the foreign persons which provide material assistance to this purpose or any blocked person for any other purpose are also subject to the risk of the designation, which is a typical US blocking sanction extraterritorial element, which subjects foreign persons dealing with a blocked person to the risk of being designated themselves, which has been replicated also in this executive order, but which is difficult to comprehend given the type of objective this order seeks to achieve and the type of persons who were designated under this order, which we would look at now. And we see here that the persons who were designated are the judges of the International Criminal Court. The judges are designated for their alleged involvement in the pursuit of US personnel for their actions in Afghanistan. It's important to note that before this order was issued and these designations made, the prosecutor of the ICC announced that the relevant ICC investigations with respect to Afghanistan will be focused on Taliban actions there and not on the actions of any other third parties, including the US military. And it's also important to note that the relevant judges, when they were approving the relevant investigations of Afghanistan, were not approving specifically the investigation into the actions of US military personnel, but were approving generally the investigation of war crimes or crimes against humanity, which could have occurred in Afghanistan with respect to all parties involved. So that was not the approval which in any sense or form targeted the US military personnel. And as I already mentioned, as a follow-up to that, Prosecutor Hahn announced that, in fairness, the third parties would not be part of that investigations as a priority basis. Nevertheless, various judges have been designated for their rather technical involvement in the matter. Another set of judges and prosecutors, including Mr. Hahn himself, were designated for issuing arrest warrants for the current Prime Minister of Israel and the former Minister of Defense, and starting the investigation as to the involvement of those persons into the crimes against humanity and war crimes committed from Gaza. Again, putting this into context, the relevant warrants were issued both against the 3 members of Hamas and 2 members of the Israeli government. So by all means, this was not something which was specifically targeting the Israeli government. Finally, we have an NGOs involved there, which is a good example of what I previously discussed, that the persons providing assistance, information, facts to the ICC are within the scope of the potential designations, as well as the UN Human Rights Rapporteur, Ms. Francesca Albanese, was designated for her report to the United Nations, pursuant to the mandate of the United Nations as to the situation in Gaza. So we see among the people who were designated quite a very different group of persons, very far from those typical targets of international economic sanctions, which we would expect to see. So what are the key takeaways of this particular sanctions regime, and what is important to note? The important to note are a few points, which is summarized in the slide, starting with the at least perceived mismatch between the objectives with the US president declared as a reason for issuing the relevant order, which is the protection of the US and the US allies' military personnel by the ICC for their actions, and the type of sanctions which were imposed against the relevant members of the International Criminal Court, which go much further than restricting this type of operations. The reason for that is that the language which was used for the relevant sanctions is a mirror language from the similar executive orders used for other type of sanctions programs. And in essence, those type of sanctions programs aim at completely blocking any type of interaction with relevant persons on any points whatsoever, to summarize the essence of them. Imposing those type of restrictions with respect to the ICC judges and the members of the prosecution office effectively, to a large extent, paralyzed their work, at least with the US NGOs or US nationals, and to a large extent also with the foreign nationals. The situation demonstrates also very unlimited powers of the US president under the legislation to introduce sanctions for the matters which one would typically not consider be the matters where international economic sanctions would be the relevant remedy. And it seems that these limits are, for the time being, very broad, hardly restricted by the relevant provisions of the statute, and in essence brings the matter of the imposition of sanctions more into the political realm rather than into the legal realm. Having said this, there are certainly challenges to this type of designations. So, for example, the challenge for a injunctive relief preventing the communication of the US persons with the ICC on the basis of the First Amendment rights has been successful. And one might expect that there would be similar challenges and the permanent relief could also be granted. So only time will show to which extent these powers would be restricted by the acts of the US judiciary. Thank you very much for watching. I trust that you found this presentation useful, and I hope to see you during my next presentations.